right, let's talk about probate. Wouldn't be discussing completely basics of estate planning if I didn't talk about probate and understanding probate. There are so many misconceptions about probate. What is probate? Probate is the legal process to administer your estate. Probate occurs after your death. Probate will either be based upon your will, if you have one, or if you don't have a will, then there still will be a probate under what is called the laws of intestacy. See, if a person doesn't have a will and they don't have a trust, they don't have anything for what happens to their assets when they're gone, the state has a plan for you. The state's plan is called the laws of intestacy, and your assets will go where the state says they go. To give you some reassurance, the state doesn't grab your assets, but the state does say, oh, you're a single person, you have 3 kids, you don't have a will or any direction to your estate plan or to your assets, your assets are going to go equally to your 3 kids, period. And that will be under the laws of intestacy. So a probate can be based on a will or it can be based on no will. But a probate occurs when there's no other way to direct where your assets go. If you had an irrevocable living trust that's working properly, then there's no probate. If you have an estate plan that was set up to avoid probate, maybe your lawyer said, we need a will for a backup, but there's no reason for probate of your estate. You don't need a trust. You don't need a probate. We're going to set up your estate plan to say, for example, your house transfers on death to your child, your bank account to your child, your life insurance, your 401k. We can set up an estate plan to avoid probate and not have a revocable living trust and all those complexities. Depends on your situation. So probate doesn't always happen. Your estate plan can avoid a probate if it makes sense, without a trust or with a trust. But let's say that there's going to be a probate. The will is filed with the court, or if there's no will, then somebody who is likely to be inheriting is going to petition the court and say, hey, I want to serve as the executor. The process is the court says, okay, you could be the executor, the personal representative. Then what your job is to give various notices to other heirs at law and beneficiaries and to the state, gather up all the assets, find out if there's any debts to pay legitimate debts. And then there's this net amount that's left. Maybe there was a house and the house needed to be sold, so you need legal authority, which you get through the probate to sell the house. Now all you have is money to divide, and then you divide what is left to the beneficiaries. Through this process, I forgot to mention, there's also an opportunity for notice to creditors to make sure that any creditors who have legitimate claims will be paid, or to also cut off any creditors so that whatever is left will be divided, and you don't have to worry about some creditor later coming back and saying, oh no, part of that was mine. So the probate, that is the probate process. It is a statutorily mandated, you do this and then this, give notice here, do this, do this, do this. I think it's for that reason that sometimes people think, oh, this is too complicated. It's complicated if you're not a lawyer. If you're a lawyer, it's just a process that you follow. If you're a non-lawyer, you can try to do it yourself. We even have on our website do-it-yourself information, because we know sometimes people want to at least try to do it themselves. But more commonly, people do need assistance with the probate. Probate is not a terribly difficult process legally here in the state of Washington. It doesn't go on for years and years. Typically, we'll go for a 6-month period. If it's beyond that, it's because maybe there's a tax return that needs to be filed, or there's some complications. Probate in the state of Washington and Idaho, the fees for it are based on how much work was involved. How much work did the lawyer need to do? Contrast that with other jurisdictions where the fees are based on a percentage of the size of the estate. That's not how we do it here in Washington and in Idaho. So probate is something that what I tell clients is avoid probate if there's no benefit. We'll set up your estate plan that way. Or we should do a probate because that's how we're able to protect money for your beneficiaries, for your surviving spouse, how we're able to create asset protection trusts, how we're able to minimize taxes. There's a lot of very, very good reasons for probate, but your estate plan should be set up so that you understand those good reasons and that you know that probate is a smart thing to do, not something that was thoughtless and it just occurred because nobody thought through whether to do probate or not, or whether there was a estate plan or not.